Okay guys, I'm Dave Magid here from Minnesota Legal Assistance. I'm going to walk you through today FCRA damages. The first area, what are we talking about when we talk about damages in law? We're talking about money. Okay, what kind of money are you entitled to? What type of compensation are you entitled to under the Fair Credit Reporting Act? Okay. Damages is typically limited to money, although damages can include specific relief. So, for example, in the Fair Credit Reporting Act context, also like removing things from a credit report, right? So right now we're going to just talk about damages in terms of the money, but there is this other element which is actually correcting the credit report, which in my experience, I have found that the CRAs and the furnishers are more than willing to work with you to actually make the corrections and actually assure that the credit report is fair and accurate after a lawsuit is commenced. Certainly not the case beforehand, but as soon as you get the right people's attention there, then they are willing to typically make those corrections. All right, so we'll step through, there's basically 4 different categories of damages that are available to you. So actual damages. Actual damages mean the damages that compensate you for harm, okay? And this is key. This is a key area of damages because this is actually a required category of damages in order to bring a case, okay? You can't just bring a case after a Supreme Court decision, Spokio. You can't just bring a case that says, hey, you violated the law, and because you violated the law, I'm entitled to this category of statutory damages, which basically just means this monetary fine of $1,000. You're not able to do that. You actually have to have real and cognizable damages, which we articulate here as actual damages. So you have to say, hey, look, this really affected me. I wasn't able to actually get credit somewhere. I applied for credit and I was denied. Something has to have actually happened to you. And the Supreme Court has even further clarified the Spokio decision in saying that within the FCRA context, to say that so long as false information just resides in a credit file, that is not enough. It has to actually be published out to somebody. So, you know, I tend to, I'll have to research this area a little bit more, but I tend to highly disagree with that decision because essentially it's saying, look, because somebody's smart enough to know that there's something on their credit report and therefore not apply for credit, now that's not going to be enough. Although I am somewhat unclear, and I think it will take further court clarification in the area if it's enough to actually allege that specific thing. I knew there was something in my credit file, therefore I didn't apply for something. I knew it, and I was going to apply for X. Give specific examples. I think that might actually qualify as actual damages. It's an articulable harm. You knew that was in your credit file, even if it was not published to somebody. This is exactly what I was going to apply for. But it's not enough to simply be like, hey, this is in my credit file and it's wrong, and therefore I think I'm entitled to damages. Not enough. You have to plead more. Now, I realize how granular that is, and we can discuss that further in a moment. When you're talking about actual damages, we're talking about there are two kind of subcategories of damages, actual damages, I should say. General and specific. General are these things that we can't really get a receipt for, right? So these are the things like pain, suffering, anxiety, frustration, the kind of things that you would expect that we've all experienced from looking at credit reports and saying, hey, this is really frustrating that, I've got kids at home and I don't have time to be dealing with this stuff, or going off and on my own time and effort and dollar, going and correcting stuff should I need credit in the future. But unfortunately, you need to do that in order to protect your rights under the FCRA, which we'll go into in other videos. But that onus is on you, and that frustration is palpable. And I think it's something that can be articulated to a court. Hey, I have to go and do all these things, and it's this huge frustration, and it's an anxiety because I may be, I don't know if my kids getting into college, and if they do get into college, I may be co-signing for a student loan in coming weeks. This is highly important. That frustration, so long as it is articulated into the complaint, would fall into that category of general damages. So again, pain, suffering, anxiety, frustration, all those things that we don't get a receipt for. By contrast, we have the secondary category, specific damages, which are the things that we have a receipt for, right? So specific damages, you might say, hey, I was going to apply for this car loan, and, I did apply for this car loan, and I was turned down for this car loan. And because I was turned down for this car loan, I was not able to get this other job that was 5 miles from my house off of a bus route. And therefore, we'll bring in an economist, often requires an expert witness, very unfortunate, but it does, requires that expert witness to say, hey, over the lifetime earnings, this is give or take what would have resulted from being able to purchase that car and go ahead and calculate that out. So those are the specific damages. Another area of specific damages you might see is higher interest rates. So this is risk-based credit decisioning. Punitive damages is another category. Punitive damages, the ceiling is not limitless with this. Okay, it's typically a multiplier of your actual and statutory damages. So that is limited. It's been limited through various cases and through tort reform. So that's, when you hear those terms, that's what's happening there. It's taking down your ability to sue the credit reporting agencies for violations of these acts. You're simply not able to get as much money, which, when you're talking about large corporations, which care very little about making small settlements, it's a huge impact on how they might make decisions or base their behavior. Statutory damages under the FCRA are limited to $1,000, so you can get up to $1,000 just as a little kicker, a bonus for essentially bringing a proper suit. Again, we're not bringing frivolous garbage suits. It's not. You have to have an actual error and go through the proper process. But so long as you have those actual damages and those are supported by having an actual error on the credit report, statutory damages are available for willful violations, okay? And then finally, this is the biggest ticket here, is the attorney's fees, okay? You're entitled to attorney's fees under the FCRA. And what does that mean? That means somebody will, if you prevail, the other side will have to pay your attorney's fees. This is in contrast to the American rule, which typically dictates that each side pay their own attorney's fees. Under the FCRA, the defendant, often in this case the CRA itself, so Equifax, TransUnion, Experian, will be required to pay your attorney's fees if you prevail. And that is a huge thing because you need to understand that this is a complex statute, even these categories of damages and the differences in the damages types and how things are pled down to actual damages will be determinative of whether or not you can have success in your case. So I would encourage you to take advantage of your right to attorney's fees and actually use a professional, which this category of damages should, in theory, allow you to have that assistance without the financial cost being assigned to you or without it being deducted from the other damages that are available to you. So this category of damages is in conclusion, this is the thing that I'd say, hey, learn more about this. But make sure that you understand you have the right to an expert and utilize your right to that, because you cannot get attorney's fees. If you bring a pro se case, and that means defending yourself, or in this case, prosecuting the case yourself, you will not be able to come back later and say, hey, this is all the time I spent on it, give me those attorney's fees. You're not an attorney, and Congress has been very clear that as a result, you are not entitled to those fees. Thank you very much. And hit like below, follow our other videos, and stay with it. Thanks so much.